Good evening, I'm Matthew Reardon, and this is a We the People News special investigation. Tonight we're going to expose one of the most egregious violations of judicial ethics in recent federal court history. I'm going to show you documented proof that U.S. Marshals sent prejudicial communications about me, a journalist, to federal judges 2 months before any criminal charges were filed. That is ex parte communication, folks. I'm going to show you how the government is now trying to hide that evidence through a provocative protective order that would deny me and potentially any defendant the right to challenge biased judges. And we're going to explain why this matters to every single American who believes in the right to a fair trial. I want to be clear about something from the start. This isn't just my story. This is about whether our justice system works, whether judges can be secretly prejudiced against defendants before charges are even filed, whether the government can hide evidence of its own misconduct. The answer to those questions will determine whether we have a justice system or just a system. Over the next 30 minutes or so, I'm going to walk through the evidence piece by piece. I'm going to show you the actual FOIA records. I'm going to explain the law. And I'm going to reveal what happens when a government that's supposed to serve the people decides instead to silence them. This is investigative journalism. This is accountability. This is people news. Let's begin. You ever heard the term BOLO? Bulletin. Be on the lookout for somebody. As a journalist, I stress test our First Amendment rights. Being an auditor is not all I do, and it's actually a very small part of what I do. But I think that just like muscles need to be exercised, I think that our rights need to be exercised. And it's clear through this FOIA request, the U.S. Marshal's Office and the United States Department of Justice are treating First Amendment auditing, independent journalism, any type of activism as crimes. And they're circulating bolos on those people. Evidence in hand right here. On June 27th of this year, the U.S. Marshal Service circulated a district alert notice. The purpose of the notice was to inform all operational employees and court security officers of Matthew Reardon. Should he appear in person, please monitor the subject closely. And blank. Reardon has recently been frequenting local, state, and federal courthouses to conduct what he describes as First Amendment audits. In the past, he has been more than cooperative than current videos show. Refer to your training and local rules from the judiciary on how to handle this type of encounter. They've got my information right there. So, got the Freedom of Information Act records that I obtained from the U.S. Marshals Service. 14 pages of emails, reports, and communications about. Page 3, you've got the smoking gun. On June 24th, 2025, a U.S. Marshal sent an email with the subject line, First Amendment Auditor Matthew Reardon. That went throughout the courthouse as we just saw, encouraging them to pass it on. All right, let's break down what's significant here. First, they're characterizing my journalism constitutionally protected. First Amendment activity is suspicious behavior. Second, they're instructing people to report on me, to surveil me, to track my movements. Third, they're attaching reports, creating a narrative, building a file. But here's the most important part. Look at who received the email. Multiple, several of them from the Louisiana Western District, United States District Courthouse. This wasn't a one-time thing. 2 days later, on June 26th, the supervisory deputy U.S. Marshal sent a follow-up email. Subject: forward, First Amendment Auditor Matthew Reardon. The message: I've attached reports detailing the encounter with Matthew Reardon. Feel free to pass along to your staff. They're encouraging the spread of this information throughout the court. Now, here's the critical question. When did these emails go out? June 24th, June 26th, 2025. When was I arrested? August 25th, 2025. 2 months later, the U.S. Marshals sent prejudicial communications about me to federal court personnel, potentially including judges, a full 2 months before any criminal charges were filed against me, creating a narrative, establishing bias, poisoning the well. Then they arrested me, which went far above and beyond any arrest. In the legal world, there's a term for this. It's called an ex parte communication. It's one of the most serious violations of judicial ethics that can occur. June 24th, 2025, U.S. Marshals send the first email to court personnel, characterizing my journalism as suspicious behavior. This is the email we just showed, June 26th, 2025. The supervisory deputy U.S. Marshal sends a follow-up encouraging staff about August 25th, 2025. I returned to the John M. Shaw Federal Courthouse in Lafayette, Louisiana, to peacefully protest on the courthouse steps, holding signs that criticize the Bolo Alert, that criticize the U.S. Marshals Service for circulating these alerts, exercising my First Amendment right to petition the government for redress of grievances. And I'm arrested. Now, let me show you. During that arrest, it's important that you understand the context. I'm on the courthouse steps. I'm outside of the courthouse doors, holding protest signs, speaking about the Bolo Alert. I'm recording, as journalists do. U.S. Marshal Hayden Nugent comes outside after inviting me into the courthouse, immediately threatening me with arrest for recording after he called me up there. I exited the building, had a few things to say about it. I returned to the public sidewalk outside of the courthouse. Marshal Nugent shortly after follows me outside. He demands that I remove the video camera from outside of the locked door of the courthouse. It's never been accessed. Entering or exiting, it's always been an emergency exit. There was never any other traffic out there. I was in close proximity to my camera. In the event of an emergency, the camera could have been moved and immediately. The problem is, they're trying to say that the camera was obstructing a door, but a door that was never used. When I refused, because I had a constitutional right to record in public, to document what our public officials were doing, I'm arrested. The charge comes down to a CFR, Code of Federal Regulations, petty federal charge. The charge: loud noise and obstruction for peaceful protest outside of a courthouse in a traditional public forum. September through October 2025, I file a motion. Well, my attorney files a motion to dismiss on First Amendment grounds, strong First Amendment grounds, arguing that my arrest was unconstitutional, provided video evidence, cited the Supreme Court precedent. The court schedules a hearing. It becomes clear that my constitutional challenge is going to proceed. based on it being unconstitutionally overbroad as well as vague. And that sounds weird. How can it be both of those? On another show, I'll get into the constitutional challenges and how those work. October 15th, 2025, today, same day, the court indicates my constitutional challenge will move forward. The government files a motion for a protective order. And here's where it gets really interesting. Let me read you what the government's motion says. Let me actually pull this up right here so you can actually see. They want to issue a protective order because discovery materials and evidence contain sensitive courthouse security operational plans and communications between the Marshal Service and the federal judges at the John Shaw Courthouse. We see on the heavily redacted FOIA request, we see the uscourts.gov email address, which I've drawn strong inference from the beginning that I believe these are judges or somebody in the judges' chambers. And right here you have the U.S. attorney that's filing for a protective order. And in the protective order, he's saying that they want to seal up the communications between the Marshal Service, the ones that did this, and the federal judges at the courthouse. There's no ifs, ands, or buts about it. Due process. All right? The Judicial Code of Ethics. But most important, due process. It requires fairness. And how can something be fair? If it's been in the loop on something, was brought into the loop on somebody where it was already unwarranted what they did, and that judge has prior working knowledge based on what the government told them. Because I never got a chance to tell my side, to show the proof. Federal Rule of Criminal Procedure 16D1 states at any time the court may, for a good cause, deny, restrict, or defer discovery or inspection, or grant other appropriate relief. So here's what I'm going to say to that. The government, the United States government, when they decided to violently accost me and charge me and all that after kidnapping me and torturing me, but when they decided to go forward, and now I'm standing trial as a criminal defendant, they unilaterally opened the door to discovery. The government cannot play these games where they're putting out disinformation like that and then trying to hide behind their power. That's very dangerous. And what's even more dangerous is if I find out any of the judicial officers connected to my case were on this email list by the U.S. Marshals. There is absolutely no way that this can ever fly because the records themselves already justified being unredacted because the conspiracy became lit when everything happened. It wasn't just hypothetical anymore. It now justified being unredacted. And you've got the United States government that actually goes to the extent, not only did they move to attach a second U.S. attorney to prosecute me, two U.S. attorneys to prosecute me for this petty, low-level bullshit charge that sees a maximum 30 days in jail. It's not about that. It's about the principles that's already been established. You can't rewrite. I mean, but they want a protective order. They want to be able to bring charges against somebody and then say, you can't get the discovery. Because what they're trying to do here. As per my attorney, they want to release the discovery to him or they want to do it through a judicial camera review. And the reason is right here. in this motion. It says it in this paragraph right here, bottom of the second page. And you can click on these documents on the website and pull full document. WTPnews.org. Hey, remember also my link tree. It's goes a couple of different ways. Linktree.com. But right here, let's read this paragraph. Certain discoverable materials are sensitive courthouse security operational plans and communications between the Marshal Service and the federal judges at the John Shaw Courthouse. Communications between security officers of other courthouses and the Marshal Service. Throughout this litigation, the defendant has posted material obtained from the government online on YouTube. According to the defendant's own statement, his incident arouses out of his desire to stress test the system. Dissemination of this would tend to reveal the methods or operational behavior of the U.S. Marshals in performing its courthouse. What it would do is it would reveal the of the corruption performed by the U.S. Marshals in the courthouse. It would shed a lot of light on what they're doing, not only to me, but I'm sure to other people. It's not isolated. Anybody that's been to a federal courthouse, I want you to do a FOIA request into the U.S. Marshal Service and the Department of Justice for anything that would have been created on you. I think you'd be surprised. I think everybody should do a checkup every so often for public records that were created on you or your YouTube channel. It's very important. You'll find a lot of lies by the government. A lot of lies by the government. It's to hide the evidence of the private communications. I believe that 100%. This isn't a series of unrelated events. This is a coordinated campaign. Surveil the journalists, prejudice the judges, arrest the journalists, hide the evidence. And if they succeed, they can do this to anyone. Now, I want to take some time to explain the legal violations here, because this is where the rubber meets the road. You might be thinking, okay, some emails were sent. Why is that such a big deal? An ex parte communication is a legal term coming from Latin, meaning from one side. In the legal context, it refers to a communication between one party or someone acting on behalf of a party and a judge without the other party being present or having an opportunity to respond. Now, why are ex parte communications prohibited? Think about it this way. Our justice system, it's supposed to be adversarial. Both sides present their evidence. Both sides make their arguments. The judge hears from everyone before making a decision. But what happens when one side gets to whisper in the judge's ear before the case even starts? When they get to shape the judge's perception without the other side knowing about it. That's not justice. It's prejudice. The Code of Conduct for United States Judges, Canon 3A, paragraph 4, explicitly states, I'm reading this correctly, a judge should not initiate, permit, or consider ex parte communications or consider other communications made to the judge outside the presence of the parties or their lawyers concerning a pending or impending proceeding. The emails were sent in June. I was arrested in August. The proceeding was impending. This is a textbook violation, but it gets worse. Let me show you the specific elements that make this particularly egregious. First, the communication was one-sided. Only the government's perspective was presented. I had no knowledge of it. I had no opportunity to respond. Second, the communication was prejudicial. It characterized my constitutionally protected journalism as suspicious behavior. It created a negative narrative about me. Third, the communication occurred before charges were filed. This wasn't about an ongoing case. This was about creating bias before a case even existed. Four, the communication went to multiple recipients within the court system, the local court system. This wasn't about a single isolated incident. This was systematic. Fifth, the communication included attachments, reports, documents that further established the prejudicial narrative. Now, what are the consequences of ex parte communications? The law is clear. When a judge receives ex parte communications about a party, that judge's impartiality can reasonably be questioned. Federal Law 28 U.S. Code Section 455A reads, any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. Shall disqualify, not may, not should consider, shall, must. So here's where we are. U.S. Marshals sent prejudicial communications, federal court personnel, potentially including judges, very likely were judges. In fact, the U.S. Attorney admitted to judges. Any judge who received those communications is required by law to recuse from my case. Here's the problem. I don't know which judges received the communications. I can't challenge bias. I don't know it exists, but I've got more than enough to show that it exists. That brings us to the due process violations. The Fifth Amendment to the United States Constitution guarantees that no person shall be deprived of life, liberty, or property without due process of law. Due process means fairness. It means notice. It means an opportunity to be heard. It means an impartial tribunal. When judges are secretly prejudiced against you before charges are filed, you don't have an impartial tribunal. When you're denied knowledge of which judges receive prejudicial communications, you can't seek their recusal. When you can't challenge bias, you don't have due process. This isn't just a technical legal violation. This strikes at the heart of what makes our justice system legitimate. If judges can be biased against defendants, and defendants can never learn about it, then the promise of equal justice under law is a lie. And that's exactly what the government is trying to make happen through their protective order. So, we just went through the protective order, all right? Now, on its face, some of the things they say might sound reasonable. Courthouse security. It sounds important, right? We want courthouses to be secure. But let's dig deeper into what they're actually asking for. The protective order would, one, prevent me from publicly disclosing any discovery materials. Two, prevent me from discussing sensitive security information with anyone except my attorneys. Three, require me to destroy all copies of discovery material after the case concludes, and according to my attorney, it would have to be monitored for me to actually review it. Because I'm conducting my duties as a journalist and what a journalist does and disseminating public information out to the public, information that the public has a duty to be aware of. do this. 4, restrict my ability to use discovery materials in any other legal proceedings. That's very key right now. I've got other lawsuits going on that actually need some of this discovery, but it's been one obstruction technique after the other. Let me tell you what this really means. If this protective order is granted, I'll never be able to tell you which judges received the ex parte communications. They say I won't be able to. They're going to have to lock me up on contempt. That's an order I'm not going to be able to follow. I can't. Because I can't willingly go to trial when my due process is completely denied. There's no process. I won't be able to disclose what information was shared. I won't be able to show you the evidence of judicial bias. It'll all be as if it never existed. The government will have successfully hidden evidence of its own judicial ethics violations. But here's what makes this particularly outrageous. The government's justification. They claim these communications must be protected for courthouse security. Let me show you why that's nonsense. First, the communications don't contain security information. They contain characterizations of my journalism as suspicious. It's not security, it's bias. Second, the communications were sent to judges and chamber staff, not just security personnel. Why do judges need security information about journalists? Third, the government itself has already disclosed much of this information through FOIA. If it was truly sensitive, they wouldn't have released it. The government filmed the same events I filmed. They waited over 20 minutes before arresting me. If there was a genuine security concern, why the delay? And finally, the protective order specifically mentions communications between the Marshal Service and federal judges. It's not about security. It's about hiding judicial bias. The government is not protecting security. They're protecting themselves from accountability. Now, let me explain what would happen if this protective order, well, actually, no, I just repeated over the same point. This protective order is granted. It sets a precedent. It tells every prosecutor in America you can prejudice judges through ex parte communications, then hide the evidence behind protective orders. It tells every defendant you might be facing biased judges, but you'll never know about it. And it tells every citizen the government can violate judicial ethics rules, and there's not a thing you can do about it. It's not a justice system, it's a cover up system. That's why this protective order must be denied. So I'm going to take a step back now and talk about why this case matters to everyone. Even if you're not a journalist, even if you've never been arrested, even if you think this could never happen to you, because here's the truth. If the government can do this to me, they can do it to anyone. Let me paint you a picture of what becomes possible if this protective order is granted. Imagine imagine you're involved in a legal dispute with the government. Maybe it's a tax case. Maybe it's a regulatory issue. Maybe you're challenging a government action. Before any charges are filed, government lawyers send emails to the judges who might hear your case. They characterize you as difficult, unreasonable, a troublemaker. They attach reports that paint you in a negative light. The judges read these emails. They form opinions about you. They develop biases. Then charges are filed. You go to court. But the judges have already decided you're a problem. You lose your case. You suspect something was wrong, but you can't prove it. You request discovery. You want to know if there were any communications between the government and the judges. The government files a protective order. They claim the communications are sensitive. The court grants it. You never learn about the ex parte communications. You never get to challenge the biased judges. You never get a fair trial. That's not hypothetical. It's what the government is trying to make possible. Plausible, in my case. It's not just about civil cases. It's about criminal as well. This is proof. Prosecutors can send prejudicial information to judges, characterizing defendants as dangerous, violent, uncooperative. Defendants would go to trial before the prejudiced judges, never knowing the deck was stacked against them from the start. Convictions would be obtained. People would go to prison. Lives would be destroyed. No one would ever know that the judges were biased from the beginning. This is why ex parte communication rules exist. It's why judicial ethics matter. This is why transparency is essential. Now, I want to address something directly. Some people might say, well, if you weren't doing anything wrong, you wouldn't have anything to worry about. Let me be very clear about this. I wasn't doing anything wrong. I was engaging in journalism. I was exercising my First Amendment rights. I was documenting government conduct. Those are constitutionally protected activities. But the government characterized them as suspicious behavior. They created a prejudicial narrative. They biased judges against me. Here's the thing. They can do that to anyone. They can characterize any behavior as suspicious. They can create any narrative they want. And if you're a whistleblower exposing government corruption, they can call you disgruntled. If you're an activist organizing protests, they can call you a troublemaker. If you're a lawyer challenging government actions, they can call you obstructions. The characterization doesn't have to be true. It just has to create bias. This case is about more than ex parte communications. It's about whether we have a justice system that's fair, transparent, and accountable. Can the government secretly prejudice judges against defendants? Can defendants be denied knowledge of judicial bias? Can evidence of government misconduct be hidden behind protective orders? Can the promise of equal justice under law be maintained when justice is administered in secret? The answer to all these questions should be no. But if this protective order is granted, the answer becomes yes. And that changes everything. So where do we go from here? I'm not going to sit back and let the government hide evidence of judicial ethics violations. I'm not going to accept a system where judges can be secretly biased against defendants. And I'm not going to stop fighting for transparency and accountability. Here's what we're doing. First, my legal team is filing a supplemental opposition to the protective order. I will be filing a supplemental brief. We're adding a new section specifically addressing the ex parte communications revealed by the FOIA records, arguing that I have an absolute right to know which judges received these communications. We're arguing that the protective order would violate my due process rights. We're arguing that transparency is essential to judicial integrity. Second, we're filing a separate motion for disclosure. We're demanding identification of all judges and court personnel who received communications, plain and simple. Complete, unredacted copies of Call, communications, dates, times, and any responses. If the government really wants to hang this thing up, give me redacted copies of anything. We're going to really hang this thing up in the system. It won't stop seeing appeals. This thing won't go to trial. We'll drag this thing out, wasting a ton of resources when it comes to this. All day, every day. We will not have trial, and this person will not willingly under his own go to trial so long as that happens, because I will not go to trial where due process was forcibly denied. As an activist, stand my ground and change that. Dates, times, any responses, any actions taken based on the communications. Third, once we get disclosure, we're filing motions, recusal. If it so happens that the judge has had communications, not trying to make that assertion. But if there's been any improper communications, you better believe the motions will be filed. Any judge who received these prejudicial communications must step aside from my case. Fourth, we're filing a complaint with the Fifth Circuit Judicial Council reporting the violations of the Code of Conduct of 4 United States judges, demanding an investigation. I will also separately be demanding an investigation by the Senate Judiciary Committee, because this is their responsibility. They have a responsibility on this. You better believe it, they do. This is a legal fight. This is a public fight. The government is trying to hide this scandal behind closed doors. I'm bringing it to the light. I'm publishing the FOIA records. I'm explaining the legal violations. Hey, look, if the government doesn't like it, maybe the government should think twice before they do some stupid shit like that. They don't get a free pass because they're the government. In fact, they're held to more accountability and more transparency than a citizen, not less. That needs to be established clear as day. Showing people what's at stake. Because here's what I've learned. Transparency is a disinfectant. When government misconduct is exposed, it becomes harder and harder to sustain. The government's counting on people not paying attention. They're counting on this being too complicated, too technical, too boring for people to care about. And they're winning a lot of the time. People, y'all need to get involved, get charged up, counter engaged. These trolls, when they're trying to support this type of stuff, support people that are going out and doing it. If you're not able to go out and truly support your rights, stand up for your rights. Cause everybody needs to have a government. Hold on. People matters. The judicial integrity matters. The right to a fair trial matters. I think people are tired of government officials who think they're above the law. Tired of prosecutors who abuse their power. Tired of judges who allow misconduct to go unchecked. Tired of a system that protects the powerful and punishes those who dare to challenge it. This case is going to be decided by a federal judge. That judge is going to have to choose, will she protect judicial integrity by denying the protective order and requiring transparency? Or will she grant the order and allow the government to hide evidence of its own misconduct? That decision will have implications far beyond my case. It will determine whether ex parte communication rules mean anything, whether judicial ethics violations can be hidden, whether defendants have a right to challenge biased judges. It'll determine whether we have a justice system or just a system. I'm going to keep fighting. I'm going to keep exposing. I'm going to keep demanding accountability, because that's what a journalist does. To summarize what I've shown you, FOIA records prove the U.S. Marshals sent prejudicial communications about me to federal court personnel, potentially including judges, 2 months before filing charges. These communications violated the Code of Conduct for United States judges by constituting ex parte communications about impending proceeding. Any judge who received these communications is required by law to recuse from my case. But I don't know which judges received it. The government is seeking a protective order to hide evidence of these communications, denying the right to challenge biased judges. If the protective order is granted, it sets a dangerous precedent that threatens the right to a fair trial for all Americans. This case matters because it exposes how fragile, how fragile, our constitutional protections really are. A journalist documents government conduct. The government surveils. They are a protest. And then they try to hide the evidence. That's not counting booking him into jail with no charge. That's not counting the torture, kidnapping. If they succeed, the message is clear. Criticize the government, and you'll be targeted, prosecuted, and denied a fair trial. You'll never even know which judges were biased against you. It's not America. It's not justice. It's tyranny with a gavel. So what can you do? First, I want you to share this investigation. I want you to share this. I want you to go to WTPnews.org. Check out those articles, those new articles with the evidence. See what they're doing. Share them. Eyes need to be on this. Post it on social media. Send it to your friends and family. Make sure people know what's happening. Send it to the news media, local news media. But I'll tell you, my experience is that these regional news stations are controlled. They get past the news. We get a doctored sense of news in the mainstream media. It's like small businesses. I believe it's a small backbone of our country. Independent journalism, I believe it's the backbone of our country. It's where you get raw and filtered news that the mainstream media is keeping away. Make sure people know what's happening. Contact your elected officials. Tell them you're concerned about ex parte communications and judicial ethics violations. Demand accountability. Support independent journalism. Support somebody. Help somebody. Together we stand, but divided we fall. 1A community is just not got together. Not together. There's so much division. People will not unify. Subscribe to We the People News. Both on YouTube. Well, YouTube, We the People News, also exposing the tyrants. Got that channel as well. We'll be differentiating the material more and more. Share our reporting. Help me continue investigating. And here's the big one. Stay informed. This case is ongoing. I'll be publishing updates as new developments occur. The government provoked this situation. The government created the bias. The government violated the rules. And the government must now accept the consequences. Transparency, accountability, and justice for all. As Justice Brandy wrote, sunlight is said to be the best of disinfectants. The government seeks to eliminate that sunlight. We demand it be preserved. I'm Matthew Reardon. This has been a We the People News special investigation. I want to thank you for watching.
So you're tuning in live for National Fuck the U.S. Marshals Day. This is We the People News. We're live outside the John M. Shaw United States Courthouse, where these tyrants with the U.S. Marshals Service think that it's okay to criminalize journalism and the First Amendment. Had bolos put out You ought to see, like, those that haven't seen the evidence, haven't seen the FOIA request. I knew that there was funny business going on. Y'all want me to come in? Hey, they're trying to wave me in the courthouse. So he just waved me in. Should I accept the invitation? I think I should accept the invitation. Hello. After you. Well, look who it is. Okay, you called me in here. You son of a bitch, I was outside on the fucking sidewalk. You told me to come in here, motherfucker. I'm going outside. You called me in here, motherfucker. You baited me in here, you piece of shit. Fucking pussy. You fucking pussy. Fuck your mom. He literally waved me in here. He told me to come inside. Was grinning, and then told me he was going to throw me in handcuffs as soon as I walked in the doors. A public building. A public building. I'm holding my ground. I'm holding the line. Got to hold the line. And you're well within your rights. You cannot get pushed away. I mean, you give them an inch and they take a mile. Got to hold the line, folks. Got to hold the line. Huh? I'm on public fucking property. Let's go. Let's go. No, you're not. I'm getting it. You ain't gonna touch my camera. You ain't touching my camera. You ain't touching my camera. I'm getting my camera.
You grab the camera and you move it right now. If you don't, I'm seizing this camera.
Is that right?
That is absolutely right.
So what? So this door.
You've got 1 second.
This door is locked.
You've got 1 second.
This door is locked.
This is an entryway. Put it on the other side of the barricade.
I'm right. I'm fine right here.
2,
I'm
1.
really. Oh! Ah! Ah!
Right, remain solid. Say again, you get the football. All right, so I'm turning. I'm turning for a question.
I want an attorney. I want an attorney. In 1971, the court drew a line in Cohen versus California. Paul Cohen's "fuck the draft jacket" wasn't polite, but it was speech. Justice Harlan's reminder: one man's vulgarity is another's lyric. Wasn't just clever phrasing. It was constitutional bedrock. The First Amendment protects the raw and the uncomfortable, because power doesn't get to dictate tone. 17 years later, NWA pushed that line further. Fuck the Police was banned from radio, condemned by politicians, and earned the group a warning letter from the FBI. But it survived. Not because gatekeepers approved, but because courts had already established in cases like Cohen that profanity and anger are protected when they are political speech. The music didn't just survive. It became an anthem against police abuse, echoing what the court had acknowledged years before. Offensiveness is not a crime. Now in 2025, I found myself living that same fight in flesh and bone. My camera was my lyric, my audit, my anthem. Yet the U.S. Marshals tried to crush it with fists instead of bans. They treated journalism like contraband, seizing equipment as if recording itself were illegal. They dragged me into cells, beat me, mocked me, and tried to rewrite the law with violence. What they could not silence with statutes, they tried to silence with shackles. The irony is bitter. The FBI once threatened NWA for words. Today, federal agents brutalize citizens for cameras. Tools of transparency. Both reveal the same truth. When speech exposes authority, authority will try to call it dangerous. Through FOIA, I had already uncovered evidence of U.S. Marshals Service bulletins and BOLOs targeting me, documents redacted so heavily you could barely read them. but enough to show they were treating journalism and First Amendment auditing as crimes. Those documents foreshadowed what came next. And now, because of what has happened, those pages must be unredacted. The conspiracy is no longer theoretical. It is lived proof. On August 25th, 2025, outside the federal courthouse in Lafayette, Louisiana, Marshal Hayden Newsom ordered me to move my camera away from a locked courthouse door. He threatened to seize it if I didn't comply. I complied. I backed up with my tripod and 4K camera in hand. That's when he attacked. He slammed me to the ground. My brand new gimbal was destroyed. My tripod shattered into pieces against me and underneath me. My 4K camera was wrecked. He violently accosted me as if press equipment was contraband. They dragged me into a holding cell. That's where Newsom drove his knuckles into my chest while I struggled to breathe. My heart was pounding, 140 to 160 beats a minute. When I knocked his arm away to stop the pain, he threatened me again and again. Assault on a federal officer. They laughed while I gasped for air. They delayed calling 911 for nearly an hour. When the paramedics finally arrived, they mocked me, saying I was just trying to delay jail. At the hospital, the indifference continued. Dismissive, condescending, unwilling to acknowledge the injuries inflicted by federal hands. When I was discharged late at night, Marshal Newsom shackled me and handed me off to Deputy Olivet of St. Martin Parish Jail. I asked before he even pulled out of the lot, "What am I being booked on?" Deputy Olivet admitted there was no charge, just a hold for the U.S. Marshals. I told him directly, transporting me without charge is kidnapping under 18 U.S. Code 1202. He claimed he was following orders. I reminded him of Nuremberg, that just following orders is never a defense. He drove me anyway. At St. Martin Parish Jail, the abuse escalated. Deputy Olivet and a female booking officer nearly broke my wrist, hoisting me by handcuffs ratcheted down so tight I could feel my bones grinding. It was torture, plain and simple. They threw me into a tiny freezing cell with only a torn blanket. I had no food the entire day. I lay on concrete in pain from my chest, my wrist, my ribs, mocked by guards who treated my suffering as entertainment. And all the while, the marshals laughed about what they had done. Laughing at destroyed equipment. Laughing at a broken body. Laughing at constitutional rights discarded like trash. This is not law enforcement. This is not justice. This is a conspiracy. One already foreshadowed in the FOIA records. One that is now spilled into the open through violent arrest, torture, medical neglect, and unlawful detention. In 1971, the Supreme Court said the government cannot criminalize vulgar speech. In 2025, the U.S. Marshals Service tried to erase that ruling with fists, with broken equipment, with shackles and cold cells. But here's the truth. They failed. I'm still here. I'm still speaking. And I will not stop. Because history will not absolve those who hide behind just following orders. It will remember those who stood. This is the warning. This is the record. And this is not the end.
Hours of operation are 8:30 a.m. to 5 p.m.
Good morning, yes, Marshall Service. Can I help you?
Good morning. I think you just transferred me. It went to a weird machine. Who is the supervisory deputy marshal?
Yes, may I ask the reason for your call?
I said, who
Maybe I
is
can
it?
transfer you to someone else.
I said, who is it? Huh?
I said, may I know the reason for your call? Maybe I can transfer you to someone else.
Well, I was trying to reach the supervisory deputy U.S. marshal. He had communicated something out. Who is the supervisory deputy U.S. marshal for up there in Oxford?
His name is William Donald.
William Donald.
Mm-hmm.
Okay. Yeah, I'm trying to get a hold of him.
One moment.
All right.
What's your name, sir?
Do what?
What is your name?
My name is Don.
Dunn.
Yeah.
What's your last name?
Well, I'd like to speak with is there an assistant available? I really honestly until I actually get speak to him, I don't want to. The U.S. Marshal Service is up to some shady shit. This is I go by Don all the time. I'll just go ahead and tell you. This is Matthew Reardon. Pass the message along to him. I don't know who the hell he thinks he is, putting out bolos. Um, you know, uh, actually communicating over state lines to Louisiana and sending over basically a bolo for journalistic activity. But I want to let him know that I'm doing some digging into him now, since he did some unfair digging into me. I'm an investigative journalist. I'm working on a story, and actually, whether or not he wants to speak to me is irrelevant. I want to give him the opportunity to at least be able to put his side out, or at least be able to give a response, something that the government's never done to me. But either way it goes, I'm going to run the story. And so if he wants to provide response to the records that I was able to obtain through FOIA from Washington D.C., I will gladly allow him to respond and put that in the story.
And it's coming from the Northern District of Mississippi.
That's right. So let him know. We the People News. I'm going to be publishing to We the People News. That's what I've been publishing to. And if I think that's a pretty slime bag move that 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 he did. I mean, and I've got the emails, you know. So if he wants to, he's more than welcome um to reach out to me and give comment. Otherwise, he can stay. He's more than welcome to stay silent. I don't have to. I don't have to put his response out there, but I'm willing to give him the opportunity to respond to what he's done and put that in the story.
Okay, and so since you give me all that, give me your last name, and I'll tell him to give you a call back.
It's Reardon, Reardon.
A-R.
Reardon.
Hold on, say it one more time, a little bit slow for me.
Reardon.
Alrighty. And your number is
That's
346-500. Alrighty, I will let him know
okay.
to give you a call back.
All right.